Yes, Mr. Darton, good morning.
Good morning.
Before we start, I should say we've read the judgment, the skeletons, one or two of the other documents, one or two of the authorities. So you can take it we have a relatively lively appreciation of the issue, but you'll doubtless take your own course, but just so that you're aware of that.
I'm grateful, my Lord. My Lord, perhaps I should just say I appear on behalf of the appellant together with Ms Vickery, and my learned friends Mr Power and Mr Hussaini appear on behalf of the respondents. My Lord, taking that indication, can I set out to you my stall as I propose to make my submissions? Picking up from your Lordship's observation in giving in reasons for allowing permission on these two grounds, your Lordship spoke of potentially contradicting provisions. I use in those very neutral terms. That's why we're here. I therefore propose to take you to what I think are the contradictory provisions. Forgive me if you feel you've read them already, but lest I miss something. Take you to the judgment to see how the judge looked at Schedule 11, and then seek to persuade you that on the judge's construction of Schedule 11, they clearly were conflicting provisions. And I'll take you to the case in relation to what I say the tests for whether they conflict are. Now, where I think that then leads us, or led me, and if I'm wrong, I will obviously stand to be corrected, is that essentially, and whilst always a question of construction is a question of construction, there are three canons in play here. One is what I would call the search for reconciliation, which is quite topical at the moment. The second is the appropriate test for exclusion clauses or limitation clauses. And the third is the principle that the general gives way to the specific. So it certainly assists me, and so I will approach it in that way, to look at those three canons as regards what the law is in relation to them, and then take you back, if I may, in more granular form to address the contract in terms of how we say it should be read, and then for the purposes of an exclusion or limitation clause to address what we say would be the effect of it on the trial judge's findings. And then look at, as it were, the surrounding background for the question of the test of a general and specific. Because I know the case of Yam Road was referred to in the judgment, and I think it's the only case we have on it. I know there are others, my Lord, including one from your Lordship, but that is how I intend to approach the matter. So first we'll say, look, this is what I think is the conflict. And it's not a potential one, it's a real one. Secondly, address you on the laws to the canons. Thirdly, take you to the contract, applying those legal principles and saying we think this is the outcome. To set out my stall, our primary submission is that the key here is reconciliation. And that there was a very easy way to reconcile what I think are the provisions in Schedule 2 of this contract with those in Schedule 11. That's our starting point, as it were. That's our first point. We say you can reconcile this whole contract. And
so your starting point, which I understand, is that they are not conflicting provisions.
exactly, my lord. So they're conflicting provisions in the way that the judge construed Schedule 11.
Yeah.
But actually, if you read Schedule 11 with, I think it's condition 13.1.3, you can make sense of it all. And I would make the submission, rightly or wrongly, that of those three canons that we've looked at, that I've outlined, reconciliation has primacy. That must be the one, that's the starting point for the court. And the judge acknowledged that, but I submit his conclusions, and we'll look at those, were in effect to say, well, if they're irreconcilable, that doesn't matter because Schedule 11 is so clear. So, my lords, I hope that's useful, and if it isn't, then by all means cut me down and say, no, we don't need to hear from you on that, or that's not helpful, we've got, you know, we don't need to know about that. But that's the way I have approached this appeal. So can I then take you, please, to where does this conflict arise? And to do that, if I could take you to the core bundle where we've got the relevant contractual clauses. Now, I intend to work from these clauses. I don't think there's any advantage to be taken by looking at the contract itself. But in brief summary, here I'm only seeking to summarise, is that at page 109 of the core bundle of this appeal.
All right, well, I've marked them up in the contract itself. It doesn't matter, but that's fine. Just give me the clauses as we as you go through.
Yes. So,
or indeed the document.
Well, it's page 100.
It's something of a smorgasbord, this contract, for a contract let following a procurement exercise. It's extremely unusual. An exchange of letters that itself refers to 21 different emails, and then an agreement document, and then 13, I think it's 13 schedules.
My lord, I would agree. Some of those schedules are quite plainly, they deal with issues which are, as it were, part of the course of the contract, and they're not really, you can just see them. There's sort of things in there you have to have as to, I can't remember, but they're not really going to the nub of the contract at all. Some of them are payment.
Well, that I'm just talking about the form of it. Is extremely unusual for a contract let pursuant to public contract regulation obligations.
Yes, my lord. What we would say there, my lord, and this was a point that didn't quite fit into my rubric, is that the effect of the public procurement regulations was that the contract, the substantial contractual terms should not change between the selecting the successful supplier and the right and the
or come to that when you look at the detail. I wasn't making a point about the background. I was making a point about the frankly amateurish way in which the documents have been put together by a contracting authority. That's really my point, that you have to rootle through a lot of stuff with not much guidance to find the relevant bits. I mean, there's an index of schedules. I don't think that's even referred to in the overarching agreement. I mean, it's not a point of dispute. People are agreed, these are the schedules. But as somebody who has, for his sins, done an awful lot of procurement work and an awful lot of contract work, this is much more like an agreement with a brickwork subcontractor.
My Lord, I don't disagree with that, and obviously whoever the author of this agreement was, I mean, it's long since passed in terms of the lawyers that were present at the time. But I acknowledge that, my Lord.
All right. So anyway, we're looking at the contract. Which bit are we looking at?
Well, it's Schedule 2.
Schedule 2, yeah.
So, as it were, these are the provisions which the appellants like. And this schedule is entitled Conditions of Supply.
Yeah.
And condition 3.4, Schedule 2 expressly preserves the appellant's statutory rights under the Sale of Goods Act. Which would include a right to recover damages. And I think under Section 52 that there's a mechanism, there's a presumption as to how you calculate those. But if it had been silent, the Sale of Goods Act would have applied, but it specifically states that it does apply.
And so damages are recoverable.
And damages are recoverable.
But does that add anything to clause 13.2?
I don't suppose it does, except perhaps for that statutory mechanism as the calculation. And perhaps, my Lord, it does actually. Yes, I think it does. I tell you why. Because one of the points we made was that with regard to negotiations leading up to the contract, whilst they're not admissible for the purposes of construction of the terms, they can be looked at for the purposes of, is it Section 14 of the Sale of Goods Act, when you look at merchantable quality of fitness for purpose. They very definitely are. So I could see an advantage there to the appellant.
But aren't we assuming, for the purposes of this application, since it's a strikeout, that the goods were not of merchantable quality or fit for purpose?
Yes, my Lord, we are. But your Lordship, it was just simply your Lordship asked me, this
all right,
is infelicitously drafted, and I'm not going to defend, but potentially, that's all I could say, my Lord. Having conceded the point, then occurred to me there might be a difference. So I just leave it there.
Yeah. Okay.
But the first point is that you have an express preservation of Sale of Goods Act, and that's 3.4. And I'm reading from page 110 of the core bund. And then paragraph 3, condition 3.8. Schedule 2 provides that the appellant is entitled to avail itself of any one or more of the remedies listed in condition 13. Then at condition 5, the respondent is to indemnify us against all liabilities, losses, damages, costs and expenses, including legal and other professional fees. And if it goes down to 5.13, any breach of warranty, any defective workmanship, or the specifications. Now, I won't labour long on the specifications, but the judge accepted, for the purposes of the application, our case that the specifications, which is just set out at Schedule 1, meant that the batteries had to have a shelf life of 10 years.
Yeah, again, that's assumed for the purposes of this application. Yeah.
But for the purposes, my Lord, when one moves on to look at limitation clauses or exclusion clauses, as I've understood the law, one looks at how much is being excluded. So for the purposes of the task undertaken by the learned trial judge, he was assuming that 10 years, as it were, we would get an indemnity if the batteries failed to achieve it. But that's the indemnity at condition 5. Then, if we go to remedies, you see there, I hope, at condition 13.1, this is page 111 of those working with the core bundle.
Yeah.
The rights that we are entitled to avail ourselves of. And I know, my lord, there's duplication. This repeats what we've previously seen. It's basically at our election.
13.1.1, I know we're not directly concerned with that, but that's extraordinarily wide, isn't it? If any product is not supplied in accordance with, etc., you can rescind the whole contract?
Yes. And I say that's a factor in my favour, because that's the right we're losing. Now, I accept, my lord, that that interpretation may be open to challenge, as it were it to be engaged. But for the purposes of those three canons, of the exclusion limitation provision, yes, that is very wide indeed.
I mean, you haven't purported to exercise
No.
that, right? But, yeah,
And I may be wrong, and I sense I'm out of my depth, but rescission is always, where it requires the assistance of the court, it's not necessarily as of right in any event. But leaving that as it is, my lord, I'm not... 13.11 is a very substantial right. And they go on, and I will... I won't read them all out, but can I draw your attention, obviously, to 13.13, because this is really the crux of it, of our primary argument. Because the remedy we enjoy is at our option to give the respondent the opportunity, at the respondent's expense, to remedy any defect or to supply replacement products. Now, when we come to look at Schedule 11, there is not a provision in Schedule 11 which actually says the respondent is entitled to supply a replacement product. But there is a provision at 13.13, and it's at our option.
Can I just ask, is this what happened? Did you rely on 13.13 to require them to supply alternative products? Or did you go elsewhere?
The reason I pause, my lord, is this, is I think some replacement products were provided. Whether anyone was acting under 13.1.3, so what has occurred in the course of this contract is there have been sort of monitoring exercises, test exercises.
But is your damages claim based upon 13.1.3 or based upon the cost of you sourcing alternative replacements from elsewhere?
We say we haven't exercised 13.1.3 in the context of our claim. Mm-hmm. And if we, and I'm sorry to jump ahead, and I hope I don't...
So just round that off. You say you've not exercised 13.1.3 because your damages claim is based on the cost of others doing the work.
It's unliquidated, my lord, and we have sought to quantify it within that criteria. But yes.
So the works haven't been done yet?
So the works haven't been done
so
yet.
It's based on the likely estimate of remedial works?
Yes. Our case, my lords, was that in the context of these meters and their electrical reading units, the cost of installation or removing is very, very significant.
Yes.
But how I say our claim is, we have a claim for general damages for breach of warranty under the indemnity. There are ways of calculating it.
Well, you've broken it down, paragraph 32 of the particulars of claim.
I have, my lord. But in actual fact, what I'm trying to say is these are not liquidated sums.
Your pleaded case is for the costs of exchanging products. With whom are you exchanging them?
Well, with another supplier. It cannot be with Elster, because they don't make them. They never made them. So I appreciate, my lord, that the nomenclature can get, but effectively it is going out into the market and getting those products.
So actually then under 13.2 that would arise, wouldn't it?
Yes. But with the benefit of hindsight, perhaps we might have done it a different way, but our position on this is because there was always a £10 million cap, and because we saw our losses as so far beyond that, there was an element of, well, we'll put these in, but it's just going to come out at 10 million, and so we're just going to stop there. Now, my lords, I've referred you to those provisions, and what I'm simply saying is that on their face, they provide us with very powerful remedies. Now, the last one is to take you to condition 17, which is at page 112 of the core bundle. And again, I know this is repetitious, but effectively it's saying each remedy is without prejudice to another remedy. Now, my lords, what I'm going to next do, if I may, is just turning over the page for those of us working for the core bundle, which is 113. Just briefly look at Schedule 11, because for the purposes of deciding whether or not there is a conflict, I submit it's tested against the judgment of the learned trial judge in his construction. But if I now take you to these provisions, and at the risk of jumping ahead in my arguments, what you will notice on Schedule 11 is, and if you read nothing but Schedule 11, it doesn't actually contain any provision saying the respondent is entitled to replace the meters. Now, had it been on its own, I could see an argument being made to say, well, you could read that in. But we contend that under the heading, the words, should a faulty device be identified in operation, the cost of an equivalent replacement device and any incidental cost shall be limited, and it says to the warranty, but it's then really in one sense referring to the table. What it's looking at is what it's expressly dealing with, what the actual words address, is the liability that the respondents would have if they replace meters. And I've used meters and AMRs as one in this sense. What it doesn't actually say is the respondent has the right to replace meters.
What do you mean by the liability they would have if they replace meters? If they replace meters, they replace meters.
Yes, but if, and this was a point that the learned trial judge picked up on, if you were to, so for instance, if we, on our case, if we engage condition 13.1.3 of Schedule 2, there is perhaps a point where the respondent would need to think as to how that would be quantified, particularly in relation to depreciation. It's probably not the right word, but if you see what I mean, as the meters get older. So, as we've looked at under Schedule 2, we enjoyed the right to require the respondent to provide us with replacement meters. There would always be an element of, I'm not sure betterment's the right word, but if a meter had been in situ for a number of years, you exercise the right to demand a replacement, under that remedy, it doesn't contain any provision to discount, as it were, for the benefit of the years you've had where the meter worked satisfactorily. So if you were the respondent, you could see a danger in not seeking to define, cap, limit your liability under 13.1.3. Because this clause goes for 15 years. Without this schedule, potentially, the appellant could have demanded a new meter in year 14. Now, if we claim damages, the court could, through its own mechanism of quantifying what would be unliquidated damages, apply a discount. But it couldn't do that under Schedule 13.1.3 because we have a right to require a replacement. So, my lords, looking at this schedule, and since we're there, if I just go through, and I hope this is not in any disagreement. When one looks at the schedule, and as the judge noticed, it doesn't tie up with example 3, that they seem to say different things, but effectively, it is setting out the respondent's liabilities if it replaces. It doesn't say Elster has a right to replace. And we say, when one looks at the question of reconciling, that really explains the whole thing. Because you can't read words into Schedule 11 which go against 13.1.3.
Isn't the difficulty with that under 13.1.3, that is your clients having the option of giving them the opportunity to remedy or supply replacements. But Schedule 11 is nothing to do with remedy or supplying replacements. Schedule 11, it refers to the cost of an equivalent replacement device, and any incidental costs shall be limited to the warranty as set out below. So on the face of it, there doesn't seem to be any connection between 13.1.3 and Schedule 11. 13.1.3 is an option your clients have to require them to carry out remedial work, whereas Schedule 11 is, however it arises and whatever it covers or may not cover, is a provision seeking to limit cost. That's to say, the amount that they would pay you, not to carry out any work, but just the amount they would pay you.
My lords, I say no. And if you just, and the reason I say that is this schedule, this table, free of charge, is obvious. So the respondent is supplying. Years 6 to 15, the respondent is supplying, but we are paying in accordance with that formula. Now, the question then is, does the respondent have a right to supply if we don't request it to do so?
So just rewinding a moment, you say the cost in Schedule 11, first sentence, should a faulty device be identified in operation, the cost, that's the cost to South East Water.
No, that's the cost to the respondent.
Is it?
Yes, sorry, my lord, you're right. I'm sorry, yes. So in other words, that's the £40 towards the installation.
So they have to, well, if you ask them to provide it, they must do so at the cost to you, which is a much lower cost, I assume, than would otherwise have been payable in the schedule.
Yes.
Yeah.
Yes, I'm
It's
sorry.
either free of charge, or it's £40,
Yes.
or it's a discounted price.
Yes. Yes, and this isn't entirely clear, but well, so in relation to meters, there is no obligation to supply once one goes to year 3, and then when one goes to year 6 in relation to AMRs, this is where you have this formula coming in, which I think it sort of reflects the depreciation of the products. So that formula, the question is, when does that formula apply? Now, my lord, I think in the course of the argument at the hearing below, reference was made to the construction case of, is it Pearce and Baxter versus High, which is that where a contractor has the right to return to site to do repairs, and you don't give the contractor that right, your damages are limited to what it would have cost the contractor. I hope I've got that right, and I say it with some
Is that in
trepidation.
the authorities bundle?
No, it isn't, my lord. But we've got copies if you wish to see it. So I think, and again, I'm some trepidation. It's a standard JCT clause that comes in, essentially with the right to come back and do snagging.
Yeah.
Now, I have understood.
Yeah, snagging. That is right. But it's quite unusual for a contract to give a contractor the right to go back and carry out extensive remedial work some years after practical completion.
I agree, my lord.
So snagging, yes, but that may be the limit of it.
But what I think is the consequence. So if the contractor or the supplier enjoys the right to remedy itself, if you don't allow the contractor to do that, it can, perhaps I should put it in those terms, reduce your damages to what it would have cost the contractor.
Yes, if it was unreasonable to effectively deny the contractor the right to come back.
Yes.
Yeah, I understand.
And then you have that scale of how, so you could have a trial on
Well, what's that got to do with this? I mean, your argument on this point is simply, well, they didn't have the right to go back. It was at your option.
Yes, but in terms of the damages, if I would submit that if this schedule is given the effect that the judge found, then there can't be a claim for damages under Schedule 2. Because your only right is to seek damages under Schedule 11. And that then would potentially be subject to this question as to what it would have cost the supplier itself. But that's a secondary effect, if you see what I mean. I hope that's, so that would be the consequence of these provisions having the effect that the learned judge found they had, I submit, is that you are obliged, in effect, to engage this machinery and request new meters. And if you don't, then you face a potential argument under the case of Pearce and Baxter versus High to say, well, you can only recover what it would have cost the contractor, the supplier. But this doesn't give you any right to damages at all. Now I'll come back to I will come to the cases on the approach to reconciliation.
Just help me with that. You say, Schedule 11, you say, doesn't give you a right to any damages at all. Doesn't it give you the right to claim the cost of an equivalent replacement device and any incidental costs subject to how it works out on the table?
Well, it would give us, at first stage, it would give us a right to request a replacement device, plus £40 if it was the first year.
A right to claim from the supplier, £40,
Yes.
you say?
Yes.
I thought a moment ago you said that was the cost.
No, that was my mistake. So that's the £40. I hope I corrected that, Michael. So
I thought you corrected it the other way around, actually. But go on. How do you say it works? Who's the cost to?
So, in the first year, we would get a new meter free of charge, plus £40 to fit the AMR, plus £40 to fit the meter.
You get paid £40.
Yes,
say? Right.
because the respondent is simply supplying us with the units. And then you follow that through so that by year 3, all you would get is a free of charge AMR. You wouldn't get a meter. And in years 6 to 15, you would only get an AMR, but after you paid a contribution in accordance with that formula. And so
years 6 and following, you pay them.
yes, I think that's agreed by the nod of heads. I think that's it. And I suggested that the reason that might be in there is to reflect what I have called the depreciation that would clearly kick in if you have a meter that's done 6 years of successful life and is replaced with a brand new meter. You could see the sense in that. You could see why the respondent would want that provision in. But for the purposes of damages, this schedule doesn't address damages at all. It doesn't address liability.
So going back to the question my lord asked you, the cost of is the cost to whom?
Well, two lots of costs.
Well, in the first line, should a faulty device be identified in operation, the cost of an equivalent replacement device and any incidental costs shall be limited to the warranty as set out below. So who is that a cost to?
Well, can I answer that in practical terms, my lord? Because I think this is troubling language for me. But I think so in practical terms, the cost of the replacement units in the relevant years is to the respondent. The cost of installing is a cost we will incur against which a contribution is made.
Well, the cost of the relevant unit, years 6 onwards, is not cost to the respondent, is it? It's what you pay the respondent, the discounted price.
Well, yes, but as I've understood it, they would still so the older the unit, the more we'd pay.
Yes, but so it's limiting the amount you would pay them. That's what it's doing. It's the discounted price, which varies over time.
In that instance, yes, but I think we're still getting a discount on it.
Yes. Right.
So effectively on that analysis, the cost is to them on your analysis for years 1 to 5, but from years 6 to 15, it's effectively a cost to you.
I think there'll be some cost to them with regard to the AMRs, as I've understood it. I mean, maybe I've got a bit because we will have to pay a contribution, but not necessarily the full price. yes, what my juniors put it to me is, there is a cost to us.
It seems to me to be contradictory depending on which column and which year you're looking at, because when it says free of charge, that must clearly mean that you don't have to pay for what is being supplied to you as a replacement. But when it then says plus £40, you say that that is not a cost to you at all, it's a contribution made to you. So it's a cost to the respondent. When you then see nothing, that's not a cost to you, that's the fact that they're not making any contribution, and therefore the cost to you is not nothing but everything. But the limitation,
My lord,
means that you don't get any right to have a contribution made.
in the context of an appeal where the lack of clarity in the schedules is a point we see in our favour.
No. Your primary submission, both parties' primary submission, is that this contract is reconcilable. The conflict and ditching bits is, as you rightly said, a secondary provision. So I'm not having either party taking refuge in lack of clarity unless we have to. So the starting point is that this is all reconcilable.
Sorry, my lord, I've moved.
And you're still developing the point that this is reconcilable with 13.1.3, and we're just looking to see, because the words start with the cost of, we're just trying to see how that works. So my lord has put to you that free of charge is that in other words, free to you, and £40, that's an amount they would pay to you. When we get to 3 to 5, the nothing is nothing for them to pay you. So therefore, if there are other costs, they would be at your to your account.
Yes. My lord, forgive me. Can I clarify in response to that, if I might, just for a moment? If there are infelicities in Schedule 11, I would contend they're of less moment if this is a warranty as we have said it to be. You could, I would submit, see why a warranty wouldn't necessarily be drafted with the clarity that a contract might. Now, I can see in other circumstances that might not be true. But what I'm trying to say, and the judge said, well, this isn't written in lawyer's language. But my lord, the fact that one can't immediately, or I can't immediately understand Schedule 11, I submit is relevant for the purposes of whether it's an exclusion clause. Because
it's not an exclusion clause.
Well, it's
Judge found it's a limitation of liability clause, which is a very different beast.
Well, it is so, my lord. But we'll turn to just what it limits, and that scales still applies. All I'm trying to submit, my lord, is simply this: is that certainly on a first reading of Schedule 11, it isn't immediately clear. And
well, the table isn't, but you do have the clarification in the 2 bullet points below.
Well, yes, as long as you ignore the third one, which contradicts.
Yeah, but we're not, at the moment, example 2 is the one that matters because this is a case about premature battery failure.
Yes, well, my lord, yes, I don't. The submission I'm doing my best to offer an explanation for what this schedule means in terms of the way it operates. I mean, there is another fundamental issue here which you would hope if a lawyer had drafted this they would have looked at, which is how do you calculate your year? Because it doesn't say that. Is it the year in which it fails or the year in which you make the request?
Can I just go, sorry to gone about this, but go back to the £40 thing. And as my lord says, that there's clarification of the warranty table provided, where it says amount stated £40 is payment contribution for installing the replacement AMR meter. Now, we're only talking about meters being supplied by the respondent. That's what this schedule deals with. So you say that is a £40 payment contribution by the respondent for it installing the replacement meter.
No, it doesn't install, it only supplies, my lord.
Right, okay. That's the key.
Yes.
So that's a contribution by the respondent to you installing.
Yes.
So that is the limitation. If it costs you £50 to install it, then you're limited to recovering £40.
Yes.
And if it costs you £30 to install, do you get £10 and put it in your pocket, or what?
I would have, my lord. That's a little pejorative. But it is a stated amount, isn't it? So the answer to that would be yes. You would get £40.
Well, it simply says it's limited, which might suggest that you are limited to your actual costs with a cap of £40 contribution.
Well, yes, if you read the words above, but the schedule says plus £40.
Okay.
I am. My submission is that when one looks at the schedule, it isn't clear. And I've taken you to my point that it doesn't specify that the respondent has the right to replace and thereby engage this warranty. But my lords, could I also draw your attention to what the warranty is said to be subject to? Because if this was a limitation on liability, then you would expect, I would submit, the respondent to want it applied in all circumstances. But actually, if one reads through 1 to 7, you see there that, and I use the term loosely, if we mistreated the units, then Schedule 11 doesn't apply. So bizarrely, we then have the benefit of our rights as set out in Schedule 2. My lords, as we are on that page, can I also draw your attention to the 7th paragraph? It also provides that the warranty period begins from date of shipment plus 2 months to allow for installation. The reason I draw that to your attention is that this clause, this provision, on the judge's construction would limit our remedies pretty much from 2 months into the contract to just what the judge found the effect of Schedule 11 is.
Sorry, it would do what?
It's anticipated that the meters will go in within 2 months. If they are in breach of specification or faulty, they will therefore fail in operation. So the ambit of this schedule on the judge's construction is extremely wide.
Again, that didn't happen, did it? In this case, they were supplied, installed, and then there were problems subsequently. I thought after some years, because the batteries didn't have the 10-year life that, on this assumption, they should have had.
I would have to go, my lord, I haven't reminded myself of and we didn't really consider the extent of the problems, but actually meters on our case have been failing within the first couple of years, within the first year, some of them. I think there's a reference to a sort of...
But they failed in operation.
But they failed in operation.
I mean, this wasn't a case, for example, where a batch of these units was checked on delivery before they were installed, and it was found that they were defective.
No, it
because
isn't.
on that basis, they wouldn't have failed in operation, and Schedule 11 wouldn't apply.
No, my lord, that must correct. But in terms of, as it were, the practical significance, can I? Because I'm thinking of the Yam Road case here. What I'm saying is that in practice, where a meter fails, it's likely to fail in operation.
Well, that depends. Depends on what checks were done prior to that, either by them or you. We're talking about goods, aren't we?
Well, my lord, I pause because this is something which would have gone to a trial, but it's...
yeah, I mean, I'm not sure that... where does this point go? Other than potentially answering your point about what a year is.
My lord, it simply goes to the fact that we say that this clause, this schedule, is likely to apply in the overwhelming circumstances in which products do not meet their specification.
Yeah.
That's it, my lord. I don't push it any further than that. So I know the time too. I'm sorry, my lord. So, in summary, we say Schedule 11 doesn't contain any express provisions saying that the respondent has the right to supply. Doesn't deal with that at all. Secondly, we say it doesn't purport to exclude liability. It doesn't purport to vary the preceding clauses. Yes, my lord, I appreciate this is an issue for trial. I've just been informed that, in fact, it's only after installation that you could actually test them anyway. That's
right. And did SEW test, did they have a testing regime?
I can't answer that, my lord, other than saying that they would obviously have checked that they read properly. I can't, my lord, that doesn't mean they didn't. I just don't know, that's what I'm saying. But,
so, first point, they didn't have the right to supply. Second point, Schedule 11 doesn't exclude liability or vary the previous clauses. Yep.
it doesn't say that.
Was there a third point?
My third point is this curious fact that it states the warranty subject to. So, the items at 1 to 7 are, in effect, provisions restricting the overuse or the mistreatment of the meters. But a meter could be mistreated, still be in breach of specification. The mistreatment could have nothing to do with the breach of spec. And then Schedule 11 would not apply. My other points are, my lords, and as one as I say, it is about the supply and in certain circumstances payment of money between each other. It doesn't in itself provide for any form of damages. But I've highlighted what I think could be its effect on the claim for damages if this schedule were breached. And then finally, my lords, I point to the fact that it's not easily understood to be more consistent with a warranty in the way that we have submitted. In other words, an additional right. And that lack of clarification must, I contend, tell the lie to the suggestion that this made the quantification of damages easier under the schedule as construed by the judge, because it doesn't. At the hearing below, I think the respondents contended this was some sort of liquidated damages cause. Quantifying what your losses would be if a replacement meter was not supplied, I submit, would be fraught with problems, because it's not easy to understand. Yeah. Now, that being so, and I'm sorry to take you to, but that is really how we, so in relation to those three canons, that's why we look at this document. And really, for the purposes of reconciliation, you mustn't read Schedule 11 in isolation. If you read Schedule 2 and then Schedule 11, I would submit the most obvious thing to do is to say, oh, well, that is going to condition 13.1.3. And I've addressed your lordships as to why the respondents might want to cap their liabilities on the right to claim a replacement under 13.1.3. Namely, that you could find someone demanding a new meter 14 years in. So, well, that...
Sorry, do I understand you to say if the purchaser exercises the option in 13.13, then Schedule 11 governs the amount that can be claimed?
Yes. Now, if Schedule 11 was just freestanding, if you didn't have Schedule 2, my lord, then I could hear the argument saying, well, clearly you should read this and say there's an implied right for the respondent to provide replacement meters. But you won't find the words there. And the circumstances in which the respondent would have the right or obligation to provide replacement meters is provided for in another part of the contract.
And so if the purchaser chooses the option in 13.13, that defines, Schedule 11 defines the limit of its rights against the supplier,
yes,
even though the contract says one remedy is without prejudice to the operation of any other remedy. You'd accept that it's a limitation.
Well, it's a day for nomenclature, but it doesn't deprive you of the remedy. It's not without, it restricts that remedy, doesn't it? So I accept that Schedule 11 would cut down a bit of Schedule 2, if you see what I mean. But it wouldn't throw it all out, which is what the learned trial judge has found. And I think it's very easy when you read Schedule 11 on its isolation to think, oh, well, clearly Elster has the right to provide replacement meters. Well, it doesn't say that. And so that's what we say about reconciliation. The other points go to those other canons, but I note the time, my lords, and you've been generous enough to allow me to sort of go through and talk these issues.
Well, that on as it were, saving the contract, your argument is based on 13.13. So you need to deal with that in detail, because that's your link.
That is our link and that is our primary case, my lords, but it's not our only point. What we would submit is if we can't reconcile this
under 13.1.3,
then they are conflicting.
yes, so that's what I say. So if we are operating on the first basis, which is that the contract is reconcilable, which is both parties' primary submission, then your submission is they are reconcilable because of the operation of 13.1.3. And the link is provided by 13.1.3, and that is cut down, you say, by Schedule 11 if 13.1.3 is operated.
Yes. But I say that if Schedule 11 applies in the way found by the trial judge, we do not enjoy the remedies set out under Schedule 2, all those remedies I've set out to you, if a device fails in operation in the pipe, which is likely to be where pretty much all of them will fail. And I say that then is a conflict. And then one has to decide which provision should prevail. And also, my lords, I say that because on the judge's construction, Schedule 11 is a limits liability, there is a more exacting standard for its clarity. And I respectfully suggest it's a bit of a sliding scale. So the more rights you lose as a consequence of the operation of Schedule 11, the clearer it needs to be, and that's picking up.
The short difficulty with that is you're not losing any rights unless you choose to, because on your case you only get to Schedule 11 through clause 13.1.3, which is at your behest.
Yes.
So it's a slightly odd situation where you're limiting your liability because you're choosing to limit your liability because you're choosing to operate 13.1.3.
On my construction, yes, this is my alternative argument, my lord. My alternative argument is that if I'm wrong on 13.13, then I say that Schedule 11 clearly conflicts with Schedule 2 because they're addressing the same.
We understand that, but if the only way on your case for Schedule 11 to work is through 13.1.3, then your primary case is that can be reconciled.
Yes.
Yeah. Okay, so then there are the principles as to construction and the principles about needing clear words if you're giving up rights. I think the court's familiar with all of that.
Yes. The rights are easily defined because I've been through those, because they're actually set out in Schedule 2, so one can tick them off, as it were. If the test is supposed to address, as it were, the consequence of the loss of the rights, which is less clear to me on the authorities, and that may be my mistake. So is it the loss of a right or the economic consequences, potential economic consequences of the loss of that right? Then the points I was going to submit to your lordships were, at paragraph 4 of the judgment, the learned trial judge records the fact that the respondent sees this, their construction, as meaning we're getting very little indeed.
Yeah.
This is at page 49 of the core bundle. They say that the effect is preventing SEW from recovering anything more than the modest individual costs which Elster would incur in providing replacements.
Yeah.
So this is a very significant limitation. Now, my lords, what I would propose to do next is to take the court to those passages in the judgment where the learned trial judge addresses these issues to set up. And that is at page 63 of the core bundle, my lords.
Yeah.
So 53 was that? 53.
63.
63, I'm sorry, my lord. Sorry, forgive me. When I take my glasses off, I kind of...
The section is 93 to 105,
Yes.
in which the judge sets out the competing submissions. Then from 97 to 100, he points out that there should not have been statements from South East Water saying what they thought the contract meant. And then his interpretation starts at 101.
Yes, my lord. And how I would describe the approach of the judge is his primary reason for deciding in favour of the respondents was his finding that the meaning of Schedule 11 was so obvious.
Yeah.
And so he doesn't really, in terms of his primary findings, regard that whether there's a conflict or no conflict. He says, well, it's so clear what it means.
Well, he's reflecting the fact that, as I keep pointing out, the parties both say there isn't a conflict. They have very different reasons for saying that, but that's the parties' primary submissions both ways. So the judge is responding to those.
Yes, my lord, but of course he does also find, he says, well, it's not a liquidated damages clause. He says, I don't agree, and it's not a limiting clause, which was the respondent's case. So he finds something slightly different from what the respondents argued for.
Yeah.
But it is his finding as to what he says is the clarity of Schedule 11 that leads him to reject our case. And if one goes over the page to paragraph 104, I submit that it's only there, and I would suggest this isn't his primary finding, that he seeks to address the question of potential conflicts by reference to the decision in Yarm Road and the general giving way to the specific.
Mm-hmm.
But that is what the learned trial judge found. And you've got my points, I hope, as to whether Schedule 11 is clear. But I submit that certainly the learned judge doesn't address, he rejects my submissions on Schedule 2, Condition 13.1.3, but he doesn't actually spell out how he says Schedule 11 really operates on its actual wording. He doesn't deal with this point that Schedule 11 is silent as to in what circumstances the respondent has the right to replace. Now, moving, so I've addressed you on the question of reconciling. And I suggest that there isn't really any reconciliation in the finding of the learned trial judge. He simply says that clause is so clear it determines liability in this instance. He does make reference to Yarn Road, and he does consider the general and the specific. But that, I would submit, is the sort of nub of his judgment. Mm-hmm. So, my lords, moving to the question of, noting the time, moving to the question of when there is an actual conflict. So I tried to tread as delicately as I could by saying a potential conflict. But we submit, and I think the case is Pagnan in the authorities bundle, which I think is item 2. So it's at page 22 of the authorities bundle.
Yeah, it's tab 2, page which?
Page 22, my lord, which is 575 in the actual authority at letter A.
Yeah.
We suggest that's the right test for where you have an actual inconsistency, an actual conflict, which you then have to resolve. And it's that an inconsistent term must contradict another term or be in conflict with it, such that effect cannot fairly be given to both clauses. And so what we simply say is, well, you can't have the right set out in Schedule 2 if you read Schedule 11 in the way that the judge found it was to be read. So it is a conflict situation. Another way to put it, and what I emphasise there, it's the words fairly are used. So it's not an absolute. I think Lewinson speaks about emasculating a term. So you can see the way in which the test is to be applied. As we say, clearly, Schedule 11 on the judge's reading emasculates Schedule 2.
Okay.
We then, so that was, I digress, my lord. With regard to reconciliation, I think we were going to stay on Pagnan. Yes, so we cited that for the, as it were, reconciliation point, as well as for the meaning as
and that's page.
That was 575. It's the same page, page 22 of the bundle, letter A, the one we've looked at.
For reconciliation?
Yes, because giving fair effect to them. But we have cited, with regard to reconciliation, I think our main case was RWE Power, which is at tab 6, my lord, of the same bundle. Paragraphs 15 and 17, which is at pages 112 and 113, I hope, of that bundle. Now, I suspect these principles are rather well-known, well-run principles to the court. So,
yeah.
As I say, I invite court to accept as part of the reconciliation process. You read Schedule 2, and then you read Schedule 11.
It shouldn't make any difference which order you read them if they're capable of being properly reconciled.
I think the danger is that if you read Schedule 11 in isolation, you read into it things that aren't there, which might be permissible if there weren't other clauses dealing with the points that you're reading in.
Anyway, you're dealing with the canons of construction. The first is reconciliation. I think you can take it as read that we're only too aware that we need to try and make sense of all of the contract if we can.
Of course. I will then move on, and then we have, and again, and I know the court's all too familiar with this because of the makeup of the court in the case of Soteria, and I won't take any, your lordship wishes me to your lordship's judgment in that case.
Which case, sorry?
Soteria.
Yes.
Do I pronounce? I think it's tab 11.
Is this on reconciliation?
No, this is on. So this is moving to the second canon: exclusion clauses and limitation clauses. And we've also the most recent.
It's got to be clear if you're giving up rights.
Yes.
Which is the paragraph?
34 and 35.
Thank you. Yeah. Anything else?
Well, I think
on that one, on exclusion clauses.
yes, I think we've also included the most recent decision in EE Limited and Virgin Mobile Homes, which is at paragraph 102, which is in the tabs bundle is tab 12. The point which we would make is that on all the cases that are cited by either side in relation to exclusion clauses, the clause concerned does actually purport to be excluding liability in some shape or form. And indeed it refers to liability or similar words. So, whereas limitation or exclusion, we are in the realms of limitation. It is, I say, this case is distinguished from those other cases. You will look at the clauses, and they clearly are stating expressly that's what they're intending to do. And the question is, did they state it clearly enough?
The judge didn't find that this was an exclusion clause. The judge found this was a clause that limited liability in a particular situation.
He did, my lord, but I do wonder whether by limiting liability he was in fact referring to this point I've raised as to the damages you would get if you didn't get a replacement or if you didn't ask for a replacement. And the reason I say that is you, and I don't think it matters very much for the purposes of the test, if it's a sliding scale. There's no doubt that we will not enjoy certain rights if Schedule 11 bears the construction found by the learned trial judge.
It's clearly not excluding their obligations. They have, on this premise, an obligation to supply a replacement product, either free of charge or at a discounted rate, which may cost them a lot of money to do so, depending on what these things cost. You can't say it's an exclusion clause because you're giving up certain rights, because in a limitation clause you're always giving up certain rights, i.e. the right to recover full damages.
Yes, my lord, and so I say that you have to look at those rights, top them up, because the more there are that you're giving up, the clearer the clause which causes you to give them up has to be. That's a, and I'm sorry to put it so crudely, but what I'm trying to say is that it doesn't. I don't think for these purposes we know what rights we will not enjoy if Schedule 11 bears the construction found by the learned trial judge. Those rights are pretty much set out in Schedule 2. I submit they're very substantive rights indeed. And I submit the consequence of that is real clarity. And I, as it were, contrast that with the position if Schedule 11 bears the construction we contend for, because then it is only applying if we choose to exercise it and addressing that scenario at our election. And as your lordship, I think, has noted, there could be circumstances where...
That's going back to reconciliation. I think the premise for your submission at the moment is that reconciliation is not possible, isn't it?
Yes, but I was drawing a comparison between the two. So even on our construction, if we exercise rights under 3.13 of Schedule 2, yes, we accept Schedule 11 limits them. But that limitation is nowhere near as great as the rights we give up on the judge's construction of Schedule 11. That was my simple point, my lord. I'm saying, well, yes, but you could see why it might do that. My lords, I note the time, and I therefore want to take you to this third canon of construction, which is the general and the specific.
Yeah.
Now, I hope I've already drawn your lordship's attention to the fact that, and I don't mean this in any way pejorative, but the general and the specific was an add-on, an additional reason I submit for the judge's findings. Okay. It wasn't his primary reason. He said, well, it's a... we then, in relation to Ham Road in my submission, I'll take you to that case, but what we submit is that there is nothing really specific about the judge's construction of Schedule 11. It will apply to almost all instances in which a product fails.
I think the canon of construction about general terms and specific terms is not so much about their effect, but about their genesis. So lengthy pro forma contractual terms or standard terms, such as the JCT contract that you mentioned, if there is a conflict, will yield to homemade terms prepared and agreed by the parties.
Yes.
That's the canon of construction. So whether Schedule 11 refers to a little or a lot of the potential consequences for defective AMR units down the line doesn't really matter. It's the documents themselves that are the subject of this canon of construction.
Well, my lord, on that test, which we are content to accept, of course, these two provisions appear in the same contract. They both enjoy the same status. It's not a case of someone sending out standard contractual terms and someone else responding with terms specifically for this contract. We have but one contract. We've no evidence. That's
always the way. There's always one contract. And we're talking about a potential conflict between one document and another. And I think all the judge was saying is that Schedule 11 is clearly homemade and Schedule 2 is clearly drafted by a lawyer.
And my response to that, my lord, if I might,
Yeah.
is to say, one, homemade is not sufficient to engage the canon of construction. The question is, are the clauses tailored for the contract? And in the cases, if one takes Yarm Road, you clearly have both parties sending out standard terms. One set of terms were more directed to the scenario, I think it was climbing on a crane or something, than the other. But there is nothing specific in any of this, and there's no findings.
That can't be right, can it, Mr. Darton? Because Schedule 11, whatever else it is aimed at a contract concerned with the delivery of AMR units and what happens if they fail in operation. Yes?
Yes, my lord.
Schedule 2 doesn't mention that. Schedule 2 mentions nothing specific at all.
Well, Schedule 2 engages a specification, and Schedule 1 contains the provision for the 10-year battery life, which on our case, which the judge accepted for the purposes of the application, was very definitely the subject of negotiation.
Yes, but that's the point. We're comparing Schedule 2 and Schedule 11. And Schedule 11 is specific to this contract. Can't be any doubt about that.
I'm not sure, my lord.
Schedule 11 has as its history an email of the 17th of March sent by Elster to SEW. For reasons known only to your procurement specialist, that email was made specifically one of the 21 emails that were said to form the contract between the parties on the 20th of April. Schedule 11 came into existence, therefore, as a result of this contract.
Of course.
And so the judge said, well, it's therefore specific, whereas Schedule 2 is general.
Well, if I might, my lord, if I might respond to that.
I'm just explaining that was what the judge...
Of course, I'm grateful, my lord, but I submit this court can't properly find that Schedule 2 wasn't drafted for this contract. It may be in very legal terms, but there's not evidence that we had provided contracts in these terms in other situations. So the fact that one is homemade and the other's drafted by lawyers does not mean that the one that's drafted by the lawyers is not specifically for this contract.
Okay.
And whilst your lordship is of course right to say there's only one contract, certainly in the other cases there's more than one document, as it were. And the learned trial judge said, well, I've got to read the whole contract as one. It's all part of the contract, because our point was under special conditions. Well, it knocks out those provisions, and that point is gone. But I don't think this court can properly find that because one part of a contract directed to a specific supply of a product in a specific circumstances was prepared by lawyers, it meets the general and specific provisions.
So what do you say the effect of this canon of construction is on this case?
It doesn't apply. It just doesn't apply.
So how do we resolve the conflict which on this assumption arises?
I say that if we can't persuade you to reconcile, then the limitation aspects of Schedule 11, knock it out. It doesn't satisfy those, because it isn't clear.
And if we're against that submission, so it's a completely level playing field, one contract, two conflicting provisions. If we get to that, then how do we resolve the conflict?
by finding that there is not the clarity in Schedule 11 to exclude the
No, well, I understand that's your first fallback position. We're assuming that there's conflict. Assume that the clarity point doesn't work. How do we, just the simple point, how are we supposed to distinguish between Schedule 2 and Schedule 11 and give one precedence over the other? The procurement specialist decided that wasn't necessary, but on this submission it becomes critical. So what do you say how do you say we should resolve, if we get there, that debate between general and specific, or between two conflicting parts of the same contract?
I would first of all say that general and specific either applies or it doesn't. So it's one can't reach for that canon of construction to resolve a conflict.
I understand that submission, which is why I'm asking you what you say, how you say we should resolve it.
In that position, it couldn't be resolved, and you would have to give priority to one provision.
And how do we do that? What principle, if you're disavowing the general specific canon of construction, what other canon of construction do you rely on to say that we could resolve that conflict in a particular way?
I think the only canon we rely on is the limitation point.
Right, so it's back to clarity.
It's back to clarity, my lord, yes.
So if
there is a...
So if conflict, it's not general / specific, but there's nothing to take its place.
Well, my lord, could you just... I'm sorry, but the quality of the question I need time to work, but I think just, my lord, I seem to think there's something in Arnold and Britain about even not looking at it in terms of exclusion clauses, about how you...
Well, don't worry. If I mean that's.
Could I, Lord, you just grant me a moment?
Well, don't worry about it now. Carry on with your other submissions. But that does seem to me to be a fairly obvious point that arises because you don't like 104 of the judge's judgment. So I'm simply trying to address what replacement we might find for it. But anyway, so I think that then, are we now under your fifth heading?
Sorry, Michael, could I just, I don't want to lose this. If you'll chair, I just want to try, if I may, to pick up on that point while it's still, I think it is.
Well, I don't want you to take time when you can do it perfectly conveniently over the short adjournment.
Yes, my lord. I'll return to that. My lords, in terms of our submissions, that is essentially the nub of it. I will, if I may turn my back, but that is really how we say this appeal goes. Now, there is a point that we've put in our skeleton that I do raise, and I know your lordship is familiar with this, but the procurement background does seem to me a matter which was relevant. The judge said that he didn't take account of the utility contract regulations because there was no evidence that they were known to the respondent. But and we put it in the scale, I think is it BCCI, there's a case, the state of the law is a background fact which one can have regard to for the purposes of construction. It doesn't depend on the party's knowledge. I mean, it would be surprising that they didn't know.
Didn't know what?
The effect of the utilities contract regulations.
But this was a public procurement exercise. Tenders were invited. There were exchanges, at least 21 of them, according to the contract. And the contract was awarded to Elster. So how does the fact that it had a public procurement background as opposed to being a contract between two limited liability companies, what difference does that make?
Because, my lord, it would mean that the Schedule 11 came in after the selection of the contractor, of the supplier. So,
and?
Well, that would then have...
That's against you, because Schedule 11 comes in after Elster had been selected, but was important enough to form a contract document. The procurement specialist said, yes, fine. So at the moment, I'm completely baffled as to how the fact that this is a public procurement exercise is a point in your favour.
Well, my lord, I'll make the submission, if I might.
Yes, please do.
Right. I submit that if Schedule 11 bears the construction found by the learned trial judge, then it's a very significant change to the terms on which the procurement exercise was conducted. If it bears the construction we contend for, it's not. And I submit for the purposes of factual matrix or background, that is relevant. And in our skeleton argument, we cited an authority with regard to the law. So I say it is a factor to make it less likely that the parties intended Schedule 11 to bear the construction contended for by the respondent. That's my point, my lord, for good or ill. It's a significant change, and I've been through with you why we say it's significant. Oh, well, just one.
You'll need to deal with that. Change from what? I've got the letter of the 19th of April with the 21 emails, which seem to set out various negotiations about various specific topics. Of which this was one towards the end, but not the last. So change to what?
So the contract doesn't have, it is only, Schedule 11 comes in at a late stage, obviously.
Well, so do a lot of things. The price is reduced after that.
Yes, but I
So it's a change to what? What is the baseline that you say this is changing and therefore the procurement background is relevant?
So in terms of when the invitations, maybe the wrong wording, but when the invitations to tender went out, as it were.
Yes, well, that's the start of a process. But they were negotiating with Elster, as is apparent from these emails in the schedule, although we don't have them, although they're contract documents. They were negotiating with Elster. Were they negotiating with other contractors?
Not, I don't think so, I don't know.
Right, so therefore this was a negotiated procurement. So therefore,
So there were other contractors.
things change in negotiations.
Yes, my lord, but I would submit this would be a very, very substantial change.
Well, as I say, you can't make that submission without supporting it by identifying that which it is changing.
Well,
it's part of the negotiations, and we know it was agreed.
well, could I make one short response in relation to that, which is that I referred you to Schedule 1 and the specification, and I would submit it is all too clear that that was very important to us. Schedule 11 emasculates much of the specification.
But it was agreed by your client.
My lord.
So that doesn't help. We're just testing this proposition.
Of course, my lord.
That in some way the procurement background makes a difference. And at the moment I just don't see it. Because it was a negotiation.
Well, my lord, you've got the bits which we moved over with regard to what we say we understood the position was. And,
Okay.
But I don't press it further than that.
All right. Yeah.
And so, my lord, perhaps turning to the point that your lordship did raise, just in this, is that the way the respondent puts their case is that they say very firmly that the drive for the literal meaning of contracts is in their favour. And they say that is a powerful reason. And the Arnold and Britton dicta. I would suggest to you that it's actually precisely the opposite. When you read Schedule 11. So trying to answer in part that question your lordship very properly threw at me, not just looking at it in terms of exclusion clauses, but you apply Arnold and Britton to this. You apply Arnold and Britton to Schedule 11, and you can't make it work without reading words into it. You can't. So it's not us that's asking you to depart from literalism. It's actually them. But my lord, you have my suspicions. I don't think they'll be bettered by repetition.
Okay. Thank you very much.
Subject to a reply. Let me just. May I just?
Yeah. No. Please do.
My learned junior has informed me I need to return to your lordship's question whether you let me or not.
No. Please do.
I'm grateful. Subject to that.
When we ask questions, it's because we want answers. It's not designed to trip anybody up. I've been saying that for 20 years, but people still don't think that it's right. If I ask a question, I want the answer. That's all. So what's the answer? Which is the question?
Your last question. If I might leave the window open with the benefit of my learned junior instructions to respond to add a little bit extra in relation to that, if you see what I mean, rather than it being in pure reply.
Which point? The procurement point?
No, my lord. If you can't reconcile and you can't, and it's not resolved by exclusion clause, and the general and the specific does not apply, how do you resolve it then?
Yeah.
That, I think, was your lordship. I hope I do justice to it.
Well, I wondered if there was a third point. I wondered if there was a third level, and it doesn't sound as if there is.
All I'm asking, my lord, is that I have a right of perhaps to make a very short point in my response, because my...
Well, let's see if there is anything, and obviously we'd have to give Mr. Power the right to respond. Yeah, okay, all right. We don't have any other questions for you. Thank you very much.
Thank you, madam.
Yes, Mr. Power.
My lords, I'm going to structure my submissions as follows, under 3 headings. Firstly, I'm going to address the scope of the appeal. Secondly, I'm going to address the natural and ordinary meaning of the words of Schedule 11 read in the context of the framework agreement as a whole, and explain why the suggestion that Schedule 11 was a provision which would apply only at SEW's election is untenable. In doing so, I will have addressed, for your lordship's reference, points 1 and 2 of ground of appeal 2, for bundle 14. There's no need to turn that up.
Mm-hmm.
Thirdly, my lords, I'm going to address the suggestions made by SEW that one should not give effect to what we submit is the clear and ordinary meaning of the words in Schedule 11. And in doing so, I will address subpoints 3, 4 and para 3 of ground 2 and ground 3. I hope your lordships will be pleased to hear that I'm not planning to take your lordships to much by way of authority.
No.
The principles of contractual construction are well known and have been set out in no less than 3 recent Supreme Court authorities. I will take your lordships just to 1 on the general and specific, if we get there. My lords, firstly, the scope of the appeal.
Yeah.
It is in my submission important to note at the outset that this is not a case where SEW has no remedy for defects in the AMR modules. Rather, the question is simply, what is the remedy? And secondly, it's important in my submission to anchor ourselves in SEW's pleaded case. And if we could go to that, please, at pages 85 and 87 of the core bundle. So the pleaded case on this issue is to be found at paragraphs 32 and 34 of the particulars of claim. And your lordships will have noted at page 85, we see at para 32 little 1 that SEW are claiming for the costs of exchanging those products. And then at 6, the anticipated costs of replacing other products. And at para 34, at page 86, they seek an indemnity at 34.1 for the costs of exchanging products. For your lordship's notes, the difference in the figures, if one has noted that, are explained by the different starting points. It appears that damages are claimed only for products supplied since 2016, presumably because claims for modules supplied before then are time barred, whereas it's alleged in respect to the indemnity at 34.1 that they can get the cost of exchanging all of the products that have failed since 2016, but that's just in case there's a query on that. But the important point is what is pleaded. They are seeking from my client the costs of exchanging or replacing products. The judge struck out those paragraphs, as well as others, as being inconsistent with Schedule 11, and it is with those pleas that this appeal is concerned. And I emphasise that because, notably, what is not pleaded is that SEW seek damages for the difference in value between the value of the goods at the time of delivery and the value they would have had if they fulfilled the warranty. So it's not a diminution in value claim as pleaded. So the question for this court is simply this: whether the pleas at 32.1 and 6 and 34.1 for the costs of replacing or exchanging products can be maintained.
32, just give me the sub-paragraph
32
reference.
1 and little 6 and 34.1, whether those can be maintained, that claim for the costs of exchanging or replacing products can be maintained in light of the limitation in Schedule 11.
We're to understand those as a plea for the cost of replacing or exchanging by going out into the market rather than going to you. Is that right?
Precisely, my lord. That's how we understand it, yes. But they're going to, if they ever do it, go out, buy those from a third party and claim for the market value of that replacement from us. Precisely.
So, for example, the claim for loss of revenue
Yes.
is not affected.
I'm sorry, I missed that.
Is not affected.
Well,
That's 32.5. Is that the subject of the strikeout and the judge's order?
that was struck out, but there's no appeal against that. It was struck out because of a different provision to which I would take your lordship.
Okay,
which is
fine.
important.
Sorry.
9.4.
So the judge's order against which there's an appeal
Yes,
affects 32.1 and 6 and 34.1.
precisely. And I emphasise it because of the language. I mean, maybe a somewhat forensic point, but I submit it's greater than a forensic point. When you're seeking the cost of exchanging or the cost of replacing, and then you look against Schedule 11, which talks precisely in those terms of the costs of replacing, I say that's a strong point in my favour, but I will come to that in a moment.
But as I understand it, have I got this right? The judge has actually struck out everything and says the whole case needs to be reformulated as per Schedule 11. Is that right?
Well, some of the provisions aren't sustainable, and there's no appeal against them. So, for example,
Yes. But he's not dismissed the action because he accepts there could be a claim under Schedule 11. But all of items 1 to 7 are currently struck out. Is that right?
Yes, my lord.
Yes.
And actually, on that point, I had it in my note. Your lordship is quite right. It's para 129 of the judgment. It may be worth just turning that up. It's page 69. Because this is the background point that it's not suggesting there's no remedy. As Lord Justice Mayles rightly stated, the question is what remedy can be maintained, and it needs to be consistent with Schedule 11. So at 129, his lordship raises the point. The question which arises is whether or not, this is in the second sentence, the middle of the paragraph, the question which arises on our case is whether or not SEW can maintain a damages or other monetary claim based either on the alleged failure by Elster to comply with its Schedule 11 obligations or on the claim being limited to the cost to Elster of complying with its Schedule 11 obligations. Such issues can only be determined even when an alternative pleaded case is advanced. So yes, we were expecting an alternative pleading, but obviously instead we've had the challenge to the judgment. But I do say that once the scope of the appeal has been properly defined, it becomes clear in my submission that this appeal should be dismissed. So I turn to my second heading, which is the clear and ordinary meaning of the words of Schedule 11 in the context of the framework agreement as a whole. As to the importance of the language of a provision in construing its meaning, I need only remind the court of the passage from Arnold and Britton, paragraph 17. I won't take your lordships to it, it's very well known, but it's tab 7, page 126 for your lordships reference, but it talks of the primacy of the language. Now, as Lord Justice Coulson noted in argument, the starting point here on the facts, undisputed, is that we are concerned in this case with meters which were installed and where faults in the AMR modules were identified in operation. And we can see that from the pleading. So if we take page 76 of the core bundle and start at paragraph 8, it is said that the framework agreement stated that it would come into force on the 30th of April 2010. So that's when the framework agreement comes into force. And then at 10, on page 78, following the execution of the framework agreement, the defendant commenced supplying the claimant with products, which the claimant then installed in the service pipes of its customers so that their supply of water could be electronically metered. And then it's 11. By 2012-2013, so 2 to 3 years after the execution of the framework agreement, the claimant had found a number of the products that it had installed to have failed in that they could not be read remotely. Now, my learned friend has already taken your lordship some of the relevant contractual clauses. Your lordships will be aware of Schedule 1, which was the specification that of a 10-year battery life. There's a dispute as to whether that was, in effect, a warranty that a battery would last for 10 years, or whether it was a design warranty in the sense that it was a promise that it would be designed to have that capacity. But there's no need for that to be resolved at this hearing.
Although, according to the pleading, the defects which were found 2 or 3 years down the line were defects which had existed, at least in some cases, from the beginning.
That is the pleaded case. Yes. My learned friend relies heavily on the Schedule 2 conditions of supply. And if I could take those from the relevant contractual clauses, which are at tab 9. So Schedule 2 is at page 109. And your lordships are now familiar with these provisions. There's indemnity provisions at 5 in general terms, and then there are provisions at 13, the remedies. And I note that that is a saving provision on its face to ensure that the purchaser, this is at page 111, shall be entitled to avail itself of any one or more of the following remedies at its discretion, whether or not the products have been accepted by the purchaser. So it is to preserve these remedies in the event of acceptance. And then there's a list of general remedies. Now here, SEW has opted to pursue the path of 13.1.6 to claim such damages as may have been sustained in consequence of the supplier's breach. We'll come to it later perhaps, but it is said repeatedly that Schedule 11 removes the ability of SEW to choose which remedy. Well, we've had an election here, which is to sue my client for damages under 13.16. Now, an important point on the framework agreement, which my learned friend hasn't touched on, is that on its face, the ability to claim damages within the framework agreement is not unlimited. And we can see that when one looks at clause 9.4 of the body of the framework agreement, which is at page 107. So this clause provides that in no circumstances shall the supplier be liable under this agreement, contractual or otherwise, for any loss of profit, business, goodwill, contracts, revenues, or anticipated savings, or for any special or indirect or consequential damage of any nature whatsoever. So it's page 107, clause 9.4 of the body of the framework agreement. And that, I submit, is an important provision when construing Schedule 11, because notwithstanding the general words of clause 13.16, which permit SEW to seek damages, the right to do so is qualified elsewhere in the agreement. There is no dispute about that, and there could not be. And in fact, that was one of the reasons why the learned judge struck out some of the other aspects, and there's no appeal.
Because they were claims for loss of profit or contracts or whatever.
Precisely. precisely. So there's no appeal against that. So the oddity of my learned friend's case is that, he submits in effect that there's something odd or wrong about Schedule 11 limiting the ability to claim damages in 13. But there isn't by clause 9.4 limiting the right to claim damages. I submit that when one sees 9.4, it's then entirely unsurprising to find that the general right in clause 13.16 is, or at least could be, qualified in Schedule 11. Now, to see whether it is or not, one obviously has to read Schedule 11. There's no issue in principle as to why the right to claim damages couldn't be qualified. And it's in that context that we turn to...
Just sorry to interrupt you, just so I'm clear, because there is also reference to it. There was a cap.
Yes, my lord.
Just for my note, you don't turn me to it, but there was a supplemental deed in February 2015.
Yes, my lord.
And the cap was 10 million, is
10 million, my lord.
And is that in the supplemental deed?
Yes, my
fine.
lord.
That's fine. At some point, somebody
it's
could
on
give me
page 116, clause 3.3. So in this little clip of relevant contractual, 116, clause 3.3 of the supplemental deed.
Right. Thank you.
Clause 9.4 excludes all those specific things,
Yes.
but would not exclude, would it, the ordinary measure of damages under the Sale of Goods Act, for example?
Well, the prima facie diminution in value, my lord, it would not, no, although I will consider that further, but it wouldn't on the face of it, no, but it would cut down the right to claim damages more generally, beyond that. One has to look, therefore, to the wording of Schedule 11, which is at page 113. And I submit that the judge was right to find that this wording is very clear. I firstly note, not because it's the most important point, or I rely entirely on it, but because it is the first in time when one reads it, the heading, meter AMR warranty and fault attribution. There is no dispute between the parties that the judge was entitled to have regard to the words of the heading as a guide to the terms of Schedule 11. There's no need to turn it up, but that's para 40 of the claimant's skeleton, core bundle 12141. And that is what the judge did in my submission. The judge had regard to it, not as the absolute killer point, but as a significant point. I submit that that heading itself demonstrates or strongly suggests that this schedule goes beyond an optional warranty. What do the words fault attribution mean, I ask? Well, I submit this is on its face a scheme or a code by which the parties agreed to allocate, or in other words attribute, responsibility for faults that were identified during the operation of these products. It is, I submit, telling that at no stage has SEW ever sought to address the meaning of the words fault attribution. Rather, it seeks to ignore them. We've had no competing meaning whatsoever. It's just said that your lordships shouldn't really look at them because they're in a heading. The reason it does so is obvious. It's that the description of the schedule as one dealing with fault attribution, that is, allocating the faults between parties, is entirely inconsistent in my submission with the notion, which I will address more fully subsequently, that this is somehow some sort of optional provision. It depends on the election of SEW. in that case, if that were right, how is it attributing fault? Or
Well,
liability or responsibility for the faults?
The faults which are attributed are the faults in the devices,
In the devices,
rather
yes.
than the faults of the parties.
Precisely, my lord. That's why I clarified to say that it's attributing responsibility for the failures. My lord, the next point is the opening words. At the risk of labouring it, it says quite clearly, should a faulty device be identified in operation? So Schedule 11 applies on its face quite clearly where a faulty device is identified in operation, and that is the case here, irrespective of Lord Justice Mells's point that it is said that some of these products were faulty from the outset, albeit that their faults weren't discovered until later. We say that the faults were identified in operation. So therefore, on the wording of the contract, you go straight to Schedule 11 and say, as I say a reasonable commercial person would do, and say, well, what occurs then? I've got a fault identified in operation. And it says that the cost of an equivalent replacement device and any incidental costs shall be limited to, and I emphasise the words, shall be limited to, the warranty as set out below. So I do say that the clear words at Schedule 11 provide that where a faulty device is identified in operation, the cost of an equivalent replacement device is limited to what's set out in this warranty. So SEW is not entitled to claim, as it does in its pleading, my lords, the costs of a replacement or exchanged device or any incidental costs that go beyond the remedies set out in the table. That is, it's an obvious point to make, but it is what the word limited means. It is the only thing in my submission it can mean. The construction put forward by Elster gives the words of the clause their natural and ordinary meaning. In my submission, it was difficult to explain what the clause means using different language from the very clear words that which are there. It does what it says in my submission. Now,
Suppose the devices which you supply are simply not up to the job. They are they may not fail for a year or two,
yes,
but they are in very large numbers going to fail.
yes.
Do you say this clause, and that will only be discovered, at least in the first instance, when they start to fail in operation? But once they look at that and they see, well, the water was in there all along, and they're not properly sealed, and these devices are just not up to it. Do you say that the only remedy which they have in those circumstances is to accept from you more ex hypothesi faulty devices?
No, my lord, I don't go that far. My submission is restricted, obviously, to the Schedule 11 words and the pleaded case. Should a faulty device be identified in operation, you get into this territory. If, for example, they identify some defect in the product, which is across the board, and don't want to accept further products from us, we're not in Schedule 11 territory. That's not a faulty device identified in operation. We'd be in the territory of whether they can reject those products. And obviously, I'm not on my feet going to, or can't deal with a new case, if it were put, that, and it didn't happen in this case, because they didn't go on to reject products, as I understand it, but if they wanted to say, well, I'm not accepting any more products, I would agree with the thrust of your lordship's question, that I would be in difficulty saying that they're stuck with this. All we are saying is that Schedule 11 knocks out their pleaded case. That's all the judge decided.
Well, isn't that roughly where we are on the facts anyway, as I understand it, because they haven't actually replaced these devices yet. They're saying they want to get them from somebody else.
Yes.
And claim from you the cost of doing that.
Yes.
Which presumably, or at least maybe, because they have completely lost confidence in your devices.
Well, they've had these devices for years. It's not a question of rejecting any more. I mean, obviously, your lordship understands that. But what they are doing, and it's in your lordship's questions, what they want to do is go to the market and and sue us for the cost of an equivalent replacement device, which they've sourced from the market. That's their claim. They say, I'm going to spend 20 million on the costs of an equivalent replacement device, and I'd like you, SEW, to pay for it. And I say the short answer to this appeal is they can't do that because the cost of an equivalent replacement device is limited to this table. And that's it, that's the answer. And that was the answer that found favour with the judge, and I submit because it's the right one.
But free of charge necessarily implies that they will be getting the replacements from you.
Yes.
If they're
yes.
getting them from somebody else, it doesn't make sense. So,
but
so how can they, in what circumstances are they entitled to say, we don't want it from you, we just don't trust your devices. We want somebody else who can give us a proper device
yes,
which will work.
Yes, I understand that, and they go off to the market and they get ones that they trust. And then they sue my clients for the cost to them of that equivalent replacement device. So that's the case that's put against me. And they say, I want that cost of the replacement device. That's the pleaded case. And I say, well, how can they get that? Because these were faulty devices identified in operation, and the cost of an equivalent replacement device are limited to the warranty. They're not entitled at large to just sue me for the costs that they incurred in respect of third parties.
But if it's in year 3, they get nothing from you.
In respect of the... well, this is an important point, my lord. We're talking about AMR modules, so not meters here. But you're right, in the case of the meters, they would get nothing. But of course, this case is centred on the AMR modules. And just to look at that, if we may...
Sorry, what do you mean by AMR? Is that the AMR transponder?
Yes, that's the automated meter reading module.
Which is free
That's
of charge in year 3.
Yes, but I thought Lord Justice Nails was saying that in year 3 they would get nothing from my client.
Well, in year 3, they don't go to you because they don't like your devices.
Oh, I see your lordship.
They go to the market, and it costs them, I don't know what these things cost.
Yes.
It costs them whatever it costs, and they come to you, and Schedule 11 simply doesn't work in those circumstances because free of charge must refer to something that you're supplying.
Yes, I appreciate
you
that.
haven't supplied anything, and the meter contribution they get is nothing. So in year 3, if it turns out that your devices are simply not up to the job, and that has only been discovered in operation,
yes,
they have no remedy against you.
Well, they do, my lord, because they get a free of charge replacement. I take your lordship's point.
Well,
They say that they don't trust
They
it.
don't want it because they try. I'd assume they are able to prove
Yes,
that your devices are not fit for purpose,
Yes.
etc., etc.
well, there are two options in answer to that. One is that we are obliged to provide a free of charge replacement. There's no reason why that wouldn't work once they had explained the problem with the first one. So they would get a free of charge functioning replacement. If that didn't work, they would of course be able to sue for damages for that failure. But they'd also, and this is the point that
Well, if that doesn't work, then on your case, they just are entitled to another free of charge replacement, which isn't going to work.
well, my lord, they would at that point be able to sue for damages for breach of Schedule 11 for the failure to provide a free of charge replacement that functions.
Well, but it only has to have the same functionality as the one it replaces.
Sorry.
It only has to have the same functionality as the one it replaces. Paragraph 9 of the...
Yes, but that must incorporate the fact that it is a working and fit-for-purpose module in my submission, my lord. It can't mean that you can just provide a defective module. It must be envisaging that there's been a failure, it didn't work for the period which the parties hoped it would, and therefore they replace it. But the point, in answer to Lord Justice Mills's question, is that you could sue in those circumstances for the failure to comply with Schedule 11. If you supplied a defective meter, then you, pursuant to Schedule 11, then you would be in breach. And similarly, there is, and this is where one gets into the weeds of how the case will be pleaded subsequently, if the judge's decision is upheld. But you can sue, of course, for damages for breach of Schedule 11 more generally, and the debate will be what is that liability, and then one gets into the cases that we would say limit the liability to SEW's costs of sourcing that replacement. And that is an important point because, of course, I don't need to take your lordship to the evidence, but it is referenced in the evidence that's in the supplemental bundle that was adduced by Elster at first instance. But as one can imagine, there were back-to-back or similar supply contracts that Elster had with its suppliers of these modules. So what would have happened, I submit, in the ordinary course is if you seek a replacement, Elster would go and get it from the party that had supplied it with the defective meter. So the cost to it would be much more limited than the cost of it going to the market and buying a replacement. And that's why, and indeed as Mr. Darton somewhat conceded, albeit he says it's an optional schedule, it was important for Elster to limit its liability to that market price.
Can I just ask, do you say the cost in the first line of Schedule 11 means the cost to either particular party, or has it some different meaning?
My Lord, it depends which lens one looks at it. We say it's a limitation clause, so it's the cost to us. It's the cost to Elster. But of course, that has a mirror image of the fact that if Schedule 11 is circumvented, or SEW tries to circumvent Schedule 11, it will be because it's going out to the market and it's having a cost to it of buying products that it then wants to sue us for. But it is the cost to SEW shall be limited. Elster's liability is limited to the warranty, and one sees that if one works through, my lord. So just to take the examples, your lordship will have it. But year 1, year 2, obviously the obligation is on Elster to provide the free of charge replacement, plus £40 in respect of SEW's installation costs. That continues for 2 years. 3 to 5 years, there's an obligation on us to provide a free of charge replacement. And then 6 to 15 years, you get into the discounted replacements territory. But if one looks, for example, at example 2, the way that is referred to is that there will be a 47% discount of the purchase price. So it's framed in terms of the cost to Elster. We are providing a discount of the purchase price.
That works.
But they work both ways, my lord. That's why I think it's important in my submission to recognise that it's limiting our liability. But of course, they are flip sides of the same coin, I would submit, because if SEW have gone out into the market and actually incurred costs of replacement, then that's a cost to them. Similarly, if they're seeking my clients to be liable for that cost, then that would be a cost to Elster. And it's in those circumstances that the warranty applies, I submit.
So you read the first sentence effectively as saying, should a faulty device be identified in operation, the liability of Elster in respect of any cost incurred by SEW in replacing these in the market is limited to what's set out in the schedule.
My lord, I don't need to insert those words, respectively. The words say what they mean in my submission. I say, if you're in the circumstances of a faulty device being identified in operation, the cost of a replacement device is limited to. SEW plead that they want the costs of exchanging or replacing these devices. That's what they seek. That's what we saw in 32 and 34. That is the pleaded words. They seek those costs. I say they're limited.
You say you don't need to add any words, but is the meaning of the clause as I suggested?
That the meaning of the clause is that our liability, yes, for the costs of replacement from the market is limited to this. Now,
your liability to SEW for the loss it's incurred in going into the market to replace.
Yes, is limited.
That's what it means.
Yes. My lord, I note that it's 5-1. I was going to go on to deal with the next plank of SEW's appeal on Schedule 11, namely that even if I were right on the wording, that this is an optional clause and it depends on SEW's election. I can start that now, or I can come back at...
Hang on a minute. We just... there were 3
Headings, my lord.
Headings, scope of appeal, we
Yes.
dealt with that.
Sorry, when I
Clear meaning of Schedule 11. Are
I'm
we
still on
in,
that.
We're still in that.
Yes.
Okay,
But
well,
it's just the second half of that is that I say these are the natural ordinary meaning of the words, and they say no. The natural ordinary meaning is if a request is made under 13.13, then it's limited.
So this is the link to 13.13 point.
Exactly, and I can start that now.
No, that's fine. I've made the heading, so
But it's part of my second heading.
we'll pause there. But if it's all right to everybody, because that's a convenient place, but we'll come back at 5 to 2.
Yes. Thank you, my lord.